Order. Can we start by checking the PA system at the podium? I want to make sure everyone's going to be heard this evening.
It was working. She checked it. It was working.
It's all checked?
Yep.
Okay, and 'cause we had difficulty the other night.
Right.
Okay, this is a special meeting of the Planning Board to reconsider the original Planning Board decision to approve the master plan as originally submitted in the Howland Avenue application that was remanded to the Planning Board by the Zoning Board of Appeals. This is a public informational hearing, so the public will have the opportunity to speak. The first thing on the agenda is to receive a number of correspondence that came to the Planning Board, and we will do this with one vote. The first is a letter to the Planning Board from Marissa D. Sautel, Esquire, dated August 5th, 2021, concerning the application of Haran Building Company, 208 Howland Avenue, TAP 129, Lot 53. The second is a letter to the Planning Board from Marissa D. Sautel, Esquire, dated July 23rd, 2021, concerning the application of Haran Building Company, 208 Howland Avenue, TAP 129, Lot 53.
Motion to receive.
I got two more to go. Hold on a second.
Two more.
The third is a letter to the Planning Board from Stephen McGillivray, Esquire, dated August 13th, 2021, concerning application of Haran Building Company, 208 Howland Avenue, TAP 129, Lot 53. And the fourth is an email from Melissa Welch, dated August 17th, 2021, subject stormwater issues on Howland Avenue. May I have a motion to receive these four correspondence?
Motion made.
Second.
Motion's made and seconded to receive these correspondence. Is there any discussion? All those in favor say aye.
Aye.
Opposed, nay. The motion passes. Before we get into the topic of discussion, I'd like to make a statement. First, I would like to say that I watched the video of the Zoning Board of Appeals meeting, and I want to recognize the Zoning Board of Appeals for a rigorous and fair hearing of the matter, including what I thought were several good questions and comments related to the issues at hand. I want to thank Attorney Hawes for admirably and competently representing the Planning Board during the Zoning Board of Appeals deliberations. And most importantly, I want to thank Attorney D. Sautel as acting town solicitor for her clear interpretation of the remand document and her straightforward guidance to the Planning Board. And at this point, I'd like to recognize Attorney D. Sautel to go over the remand document and the subsequent correspondence.
Good evening. Given the large volume of documents that have been submitted as part of your agenda packet tonight, I am endeavoring to keep things as simple and streamlined as possible, but feel free to stop me if you think that I'm going too quickly over the issues or if you have any questions along the way. By way of travel of the case, just to refresh everyone's memory here tonight, the Planning Board decision in this matter was issued on December 2nd of 2020. The Planning Board voted 5-1 to approve the subject conservation subdivision design with two conditions of approval. Following that decision being issued, an appeal was taken by several of the objectors to the project, and that hearing was held on May 25th of 2021. As part of the decision from that appeal, you should have a copy of the decision. It's dated June 9, 2021. The Zoning Board went through its recitation of the statutory standard of review, as well as its findings on several of the issues raised by the objectors. Firstly, The Zoning Board of Appeals found that approval of the subject plan with fewer lots than requested by the applicant should have been considered by the planning board. Specifically, they state that the planning board can approve the master plan with changes or conditions, including approving it with a reduction in the number of lots allowed. Secondly, the Zoning Board of Appeals found that the master plan application and the planning board should address the need for required waivers. Specifically, they stated that on the plans submitted by the applicant, there seem to exist non-conforming structures. These requests for relief, if it is determined by the planning board that they are necessary, need to be made as part of the master plan application. Thirdly, the Zoning Board of Appeals found that the applicant needs to establish that it is entitled to a 7-lot subdivision. Specifically, the zoning board states that the applicant must demonstrate to the planning board that the lots as depicted on the conventional plan are capable of supporting the proposed development given any land development constraints. Additionally, the zoning board found that the applicant submitted a conventional plan that did not include a depiction of the various land development constraints related to the subject parcel, including possible location of wells, septic facilities, residences, and some wetland features. Consequently, as a result of these findings, the zoning board indicates in its decision that the planning board needs this information to determine how many lots should be allowed in a conservation subdivision. And lastly, the zoning board discusses the town's comprehensive plan and indicates that the planning board should make specific findings that the evidence supports or does not support the express goals and policies of Middletown's comprehensive plan. Following the zoning board decision, the matter was remanded back to the planning board, which is why we're here tonight. The other documents that you have in your agenda packet are several correspondences between the attorneys, and I recognize that they're nuanced and a little bit difficult to follow at some points, but bottom line is, and I'm sure the attorneys for the objectors will speak up if they feel they need to, but in my office's opinion, the bottom line at this point is a threshold issue, whether the planning board is going to require additional information from the applicant. I will caution you that it's ultimately up to the applicant whether they want to submit additional information. They could insist tonight that you render a decision based on what you have in front of you. That being the threshold issue, there are some other issues that have come up between the attorneys. Ultimately, the zoning board's decision speaks for itself. I summarize the main issues that I think need to be addressed, and I don't think that there's a fundamental misunderstanding between the attorneys. As I said, the decision speaks for itself. We did not take an appeal of the zoning board decision, so what they decided stands. But you still have a job to do in terms of your evaluation of the application materials. So I think, again, the first question that needs to be asked tonight is of the applicant and what they would prefer to do moving forward.
I'm game.
I just want to make sure I'm clear and the board is clear on what you're saying. Are you saying that it's up to the board whether, well, it's up to the applicant whether the applicant wishes to submit additional material?
Yes, you cannot force an applicant to invest further time or resources into a project that they own. You can request it like you do at any other meeting, but you cannot demand that they make those additional submittals. If they decide that they don't want to make those additional submittals, that's their decision, and you can render a decision based on what you have in front of you and what the zoning board has directed you to review. Additionally, there is another element to that issue that the case law in Rhode Island is very clear. If the members of this board feel as though they have, think that they have enough information before them tonight to render a decision, you do not have to request or move forward with a new hearing. It's up to you whether you feel as though, or think that you have the information, data, and the required materials to make a decision without a new hearing. That's another issue that was discussed in the attorney correspondences.
A lot of what this hinges on is whether engineering information will be submitted. Up till now, at least as much as I've been involved with planning board matters, we have not had engineering information submitted for master plan approval consideration. The engineering information came forward with the development plan review. Are you then saying that it's up to the applicant if they wish to submit engineering information for master plan approval?
Ultimately, yeah, that's the risk that they would take in making a decision about whether they want to submit more information or not. Keep in mind that both the objectors and the applicant have the right to appeal any decision that you make here tonight. So,
And a follow-up question is the planning board required to consider engineering information for master plan approval?
the only information the zoning board has sent back to you on remand and has told you that you should consider is information related to the, I'm going to get this backwards, I apologize. The conventional plan? Is it the conventional plan that was missing certain elements? septic
Conservation
system, wells-
plan was the one that was submitted for approval. Conservation plan.
So the conventional plan is what
Lacking.
the zoning board is telling you on remand that you should be considering additional information. But again, if the applicant doesn't want to submit that, that's their decision.
Okay. Questions from the planning board members to the attorney? Go ahead, Art.
As I said before, the first time we went through this, my experience with master plan approval is very simple. It is a conceptual review, period. And I think, as Marissa outlined in her first letter to the planning board, it's contained that way. And when we started to get into engineering information, I protested because I'm convinced, with considerable experience in this matter, that we were slipping out of master plan approval and getting into preliminary. And that's why I voted against the project at that time. And I want to reconfirm from our attorney exactly what master plan is and isn't. And in that portion, I would say that engineering information on this project, master plan approval, is really out of order, in my opinion and my experience.
Question. Mike and then Bill.
We haven't opened a public hearing either.
What's that?
We haven't opened a public hearing.
It's the public information.
Okay.
Don't keep it. Mike and then Bill.
On the conservation plan, the information on the location of homes, septic systems was provided, but it wasn't provided on the conventional plan. That, to me, isn't necessarily engineering information. I guess the potential location of those items and their proximity to any type of sensitive, areas, like wetlands and so forth like that. Is that considered engineering information?
Well, as a layman, I would say it is.
Yeah.
Usually when it's considered, yeah.
Okay. Because it was provided on the conservation plan, and I see that they're objecting that it wasn't provided on the conventional plan. So I guess the question comes down to whether that's considered, detailed engineering information. And eventually, one of the items that came up, and I don't think it was addressed, we came to the conclusion that 7 homes were allowable based upon the amount of buildable land and the zoning area and the zoning area, and it came up with 7 lots. Now, is there anything more additional required to determine, how many lots are allowed, at this stage?
Under the subdivision regulations, the procedures for conservation development specify that the determination of the basic lot yield on a conservation plan is through the formula provided in the regulation. So that's what the applicant has done. The calculation is provided on the subdivision plan, indicating that using that formula, I think the actual number that it came up with was 7.5 lots based on buildable lot area, and that resulted in the 7 lots proposed.
And, you know, one of the things that we questioned was, you know, later on is, you know, if we determine that there are some issues with 7 homes or 7 lots on that site, we could reduce it, you know, at a later stage of review, like the preliminary plan review. No, that hasn't been discussed. As far as I know, I think that's still an option.
Is that true?
Yes.
Yeah.
Yes.
Okay,
I just want it recorded.
okay. Let's see, okay, I think that's it.
Okay, Bill?
Thank you. Thank you, Marissa, for your explanation on it. It was helpful. And I concur with Art and with Mike, as a matter of fact, on what we're here to do. A couple of things, Marissa, you had said, if we rehear the case and the objectors or applicant could take an appeal to it, does the appeal go back to zoning?
That's a great question. I've never actually had that happen in my entire career. So I'll take some feedback from the other attorneys in the audience.
That's not a
if they've
real
got
deal breaker for me, I'm
experience, but
sorry. I'm just curious.
I think so. I think the statute, I mean, you follow the statute once again.
Okay. So if we dial it down to just the conclusion of the zoning board, and based on what I said, because I concur with Art and Mike, there are some missing elements of the conventional plan. So I'm prepared to rehear and ask the applicant to provide that information, which I think is relatively simple to be done, and we can move forward. And like Mike said, a master plan approval with 7 lots is one thing, but if the engineering as a preliminary plan discussion application would support, may or may not support 7 lots. That's the way the process is. My last question is, the instructions are that the planning board, quote, rehear the application. What constitutes rehearing? I guess that's where I'm just kind of hung right now. I mean, I'm prepared to go forward if this is considered a rehearing, and I would like to hear from the applicant as well on what they are prepared to do.
We'll get there.
But I guess that's the question to you is, if we go forward with this, rehearing it, subject to what the applicant may or may not want to do, are we meeting that obligation of the zoning board's conclusion?
It would not be a brand-new hearing. It's not
Right.
something called de novo, which means brand new, starting over. It would be a hearing to address the issues that the zoning board pointed out, and again, subject to what the applicant's wishes are at this point. But it's not a brand-new hearing.
Yeah, I'm good.
You all set?
Thank you.
Art?
Thank you,
So-
Marissa.
Again, I want to come back and be clear on your first letter to the planning board. And I was confused at the very end in the last page on having a second hearing may not be necessary. So is it semantics we're talking about? This is a second hearing as far as I'm concerned, because I'm sitting here. So we are having a second hearing. I mean, if it's not a hearing, what do we call it? Or is it just is that lawyer language that I don't know about?
Yeah, the difference is that, and this issue has been litigated, so you're not alone in asking this question, but the difference is the rehearing it's a remand from the zoning board. The question remains, okay, what do we do with what the zoning board told us? Do we feel as though we need more information? Do we need more testimony? Do we need more witnesses and exhibits? Or do we think that we have enough evidence in the record currently to allow us to make findings of fact and conclusions of law? So that's the nuance with this
Okay.
term rehearing.
Thank you.
Other questions for Marissa? No? Does the applicant wish to speak?
Thank you very much, Mr. Chairman, members of the board. Jay Lynch from the law firm of Morver, Godamo, Lynch on behalf of the applicant. We were prepared to proceed this evening based upon Ms. Desautel's opinion to the board that you were free to give a decision based upon the information we've already provided. And if you want any additional information from us, we'll be happy to provide it to you. So, you know, listening to the questions and your discussion, if you want the applicant to submit any additional information on the conventional plan, let us know what it is, and we can get that to you. Keeping in mind that we still are at master plan stage. You know, I don't think it's appropriate for you to come back and ask us to to prove that we can have 7 septic systems on the conventional plan. But if you want any additional information on that conventional plan, we can provide it to you. Ms. Small is on vacation, so we won't be able to get it to you this evening, but if you want to continue this to another date, we're happy with that. But we just need some guidance from the board as to, first of all, if you do need any additional information, and what particular information you're looking for.
If the applicant is willing, and based on my understanding of what the remand requires, I would say you should supply the same information that was supplied for the conventional plan.
Conservation plan.
For the conservation plan, thank you. And no more. Is that acceptable with everyone?
Yeah,
That's agreeable.
Is that agreeable with you?
That is, I can have, well, we have to put the same information that we had on the conventional plan, on the conservation plan, on the conventional.
no, point of order,
Hold on.
really, if he's
Hold
going to
on.
testify, then he should come up. But,
Do you want to bring him up and come up, identify yourself, and ask
But,
the questions for the record,
well,
please?
yeah, can I have a question first before?
Yeah,
What you said, Paul, works for me.
yeah.
So let them sort that out. Let them submit the appropriate material.
Well, it's an open public information. It's informal. Let them, let's hear what his concerns are. He's the applicant.
Mark Horan, Horan Building.
I'm sorry, I didn't hear
Yeah, Mark Horan, Horan Building.
Speak into the microphone, please.
Mark Horan, Horan Building Company.
Thank you.
So,
Speak into the microphone.
I had a conversation with Rita this afternoon in reviewing.
I thought you were going to ask clarifying questions.
I am.
Okay.
I'm prefacing it. To me, the same information that's on the conventional plan is on the conservation plan. I'm not sure what is lacking. So if I could, you could direct us as to exactly what you feel is missing. 'Cause I'm unclear.
Well, I would suggest that you sit down with the town planner who can go over the plans with you and identify exactly what's on the conservation plan that needs to be on the conventional plan.
And I did that this afternoon with Rita.
So what's the issue then?
But we don't have
I
that.
don't know. So the test holes are shown on both plans? The houses are shown on both plans? The locations?
Well,
are
the contention is that information is given on the conservation plan that is not given on the conventional plan.
Okay, and my simple question is, please be specific. Tell me what that is.
I can be specific for you.
Thank you.
Page 6 of the zoning board decision specifically indicates that location of wells, septic facilities, residences, and some wetland features were missing. So that, from the letter of the
Just a
decision.
general comment, not on any specific lots or just in general?
For the entire development.
So my next question is are those requirements for the master plan approval?
Well, that's the 64.
Because we went through this process through TRC.
We've gone through a vote. It was appealed to the zoning board of appeals. They came back with their remand ruling, and they're requesting that that information be provided. So,
Frankly, I think it's simple information that can be put on the plan, that's there. I think it's laid out pretty clearly, and I think it's readily available, that it's a matter of transferring onto that plan. I mean, I think it's pretty benign information.
Just basically the location of the home and the location of the septic system.
I'm prepared to.
Mr. Lynch, anything else?
No, that's it. So if
Okay.
you know, we'll be happy to do that. I don't know if you want to set a date for us to come back, and we'll provide that information.
Before we do that, I would like to hear if the objectors have anything to say.
Thank you, Mr. Chairman. Steve McGilvery on behalf of the objectors. There's really not a lot of nuance here, I'm afraid to say. The planning board issued a decision which was appealed to the Zoning Board of Appeals. And at that time, Mr. Lynch, Ms. DeSotel made the argument that you're hearing a little bit tonight, which is, you don't need any more information. This is the master plan stage. The Zoning Board of Appeals didn't agree. And they sent it back here with very specific instructions. And the instructions, as Ms. DeSotel read in part on page 6, delineate exactly what was missing from the conventional plan. It makes reference not only to what was the information that was provided on the conservation plan, but it also provides this list of information that should have been given the first time. It also tells the planning board, instructs the planning board, that you're to ensure that this information is provided so that you can make a informed decision that under the conventional rules, that this property can sustain 7 lots. Because that's really the question at the end of the day is, are you gonna get 7 lots under a conservation plan? Because if you are, you gotta be able to yield that same number of lots under a conventional plan. So there is no real discretion here. You know, I may agree with Mr. Weber that this is the master plan stage and it's all conceptual. You don't need any of this information. The Zoning Board of Appeals has disagreed and they've stated exactly what's required. The decision came out June 9th. And it says you're to resubmit with a conventional plan. Now we're here with all of our witnesses, ready for a hearing, and they get up and say, the applicant gets up and says, we didn't know what was required of us. We didn't know. Their application tonight is incomplete according to the zoning board. And so, given that, I think the board has to deny the application. Or tell them to resubmit the entire application, which is what the zoning board said. Resubmit the application with the additional information and start from scratch. The Conservation Commission was going to consider this additional information. My understanding recently, they could not because they didn't have the additional information. It should go to the Conservation Commission first with this additional information. And we still stand by the fact that the town should probably get its own engineer at some point and figure out exactly what this property can yield from an engineering standpoint. But to get up and say that we didn't know what was required of us is just not credible. And so what's happened is we're appearing here today on an incomplete application, and it should be denied.
Thank you. Anyone else from the objectors who wishes to speak? Anyone from the public wish to speak?
Melissa Welch, 535 Walcott Avenue. I'm also a member of the Historic Preservation Trust of St. Columba's Chapel. And I wanted to speak to the board tonight to raise an issue related to this development, and that has to do with stormwater runoff in this location, specifically as concerns St. Columba's Chapel in the area of Vaucluse Avenue at the corner of the southwest corner of the churchyard property. As many of you know, St. Columba's is a beautiful and historic landmark of Middletown, but there's an existing problem already with stormwater runoff in that area. And that is that stormwater tends to run off the roadway and congregate in that southwest corner of the churchyard, both inside in the churchyard and outside the stone wall along the property. Our concern is that should this development go forward, we need to seriously consider what the impact will be on increased stormwater runoff. We're going to be, if this development goes forward, it will increase impervious surfaces, which is going to lead to increased runoff. We've already got a problem in that area, so we need to consider what the additional impact might be. I don't know if this was raised previously before the Planning Board or the Zoning Board, but I wanted to make sure to get it on the record. As you know, I did submit an email to this effect, but I wanted to make the general meeting aware. I also would like to say that with my fellow members of the Historic Preservation Trust, we'd be very happy to be able to work with whatever town department might be helpful in this regard to help us address these runoff issues before any further development takes place. That could be a short-term measure as simple as adding an asphalt berm to the road to deflect some of the stormwater away from the property. It could be something more long-term that might involve some stormwater infrastructure engineering. We'd like to engage in that dialogue. I'd appreciate the Planning Board. This may not be specifically your remit, but I wanted to raise it for your awareness, and would certainly welcome any guidance or direction in terms of how we might pursue this further. I appreciate very much your consideration of this.
Thank you. The issue you're discussing is typically addressed during the preliminary plan approval stage. So it will get addressed, and I'm sure the plan department would be delighted to work with you. Anyone else from the public who wishes to speak? Okay, before I open it up for discussion with the planning board, I have a question for Marissa. Based on the comments of the attorney for the objectors, does the planning board have to reject this and request a new submission, or can we simply request that the additional information that the Zoning Board of Appeals requested be supplied and move forward with that?
The second option, that
The
you
second
can
option.
request the
We
information.
don't have to reject this and then start all over again.
That's correct.
Okay. Any other questions before we start our discussion? No? Could I get a sense of the board? How do you feel about this?
Well, I want to go somewhere else with this right now. Everybody sitting up here and a lot of people in the town spent almost 2 years writing a document called a comprehensive plan. It's got about 10 sections. It's a very sensitive document in some areas. And our land use and our open space are important elements in the comp plan. And rarely have I ever found applications not consistent with the comp plan. But I think in this case, I'm going to go out and say, I think this is an over-intensification at this particular site, because I think it's a sensitive area in our town and it needs some protection. I'm not saying no development, but I think maybe a little bit less. And I think I can support that with rereading the comp plan and the land use element. So that's my opinion, that whether we do it conventionally or in a conservation method, 7 lots are too many. What the right number is exactly, I'm not prepared to say that tonight, but I think that's my main concern about this application. And I want to be fair to the applicant, and I want to be fair to the town, I want to be fair to the people that wrote the comp plan, because that's an important document, and we've got to stick with it as much as we possibly can.
Bill?
So, but Art, you agree that, and you said it, the master plan, there's a time and a place for that, and that information that may in fact reduce the 7-lot master plan approval to 6, to 5. It may in fact do that. And even if it doesn't, you still have the right to sit up here and deny the application based on you feel that it doesn't meet the comp plan. I respect that. But I think is that accurate?
Yeah.
Yeah, so I,
In the interest of going forward, this is a discussion we probably should have at our next meeting. In the interest of going forward, and given what the acting solicitor has said and the willingness of the applicant Could I have a motion that we request the applicant to submit the information that was identified by the Zoning Board of Appeals?
I'll make the motion.
Second.
Motion's made and seconded. Is there any discussion? Bill?
Yeah, I mean, I fully support that. I think that, that we've been given sound advice, that's my belief, and I think, I think it's pretty straightforward with the way our rules and regs are laid out. I fully support that, and I think we need to have the applicant bring in the appropriate information as we laid out in item number 6. They did not stand up here tonight and said that they wouldn't do that. They questioned it for sure, but they were maybe a little unclear. I think we've all been a little unclear. But they represented that they are willing to provide that information, and I think we need to let them do that. Let's complete the record, and let's move on and get them so that into whether we approve or deny the master plan based on that. I still support it, but I want to see the information, complete the record, and we'll take our vote and let them move forward to see what happens. I think that we owe them that.
Other comments?
Well, I guess if
Go
I'm
ahead,
gonna
Art.
be, if I'm going to be a lone ranger here, I'm fine with it. I'm going to stand on exactly what I said. I don't know if anybody else feels the same way about this particular piece of property, but that's where I am.
Okay. Any other discussion? Joe?
Well, I want to respond to what Art said. I think the underpinning, Art, of this being a sensitive area and things that are identified in the comp plan, those underpinnings will be discussed and reviewed when we get additional information. So in that context, I'm not saying I disagree, but I'm saying that I think it's critically important for us to have an apples-to-apples comparison with the information that was requested so we can determine and make a decision that is consistent with the town's plan and given the sensitive nature of this area.
Just one more comment, Paul.
John, do you want to say something?
No, I have a tendency to agree with Bill Nash on this one. I think we should see all the information put forward to us. We should have a chance to see all the information put forward to us, and at another meeting, and have a chance to digest it and put it out there. It's important that we receive this information that they, by the way, have volunteered to provide for us.
Bill?
Yeah, just to thank Marissa again, I don't see this as an egregious error that is not insurmountable with the appropriate information. If they provide it, we go on with our business, we move forward, we've satisfied the zoning board's decision and their direction, their guidance, and our solicitor has confirmed that with us. So this is not as egregious as it may come across in my eyes.
Before I call the vote, just to be clear, we are requesting the same information for the conventional plan that has already been submitted for the conservation plan. Is that correct, Marissa?
Yes. Yes, that's correct.
Is that clear to everyone?
Well,
Yep.
well, I've got another question. We're requiring people now, when they come in with a development, to submit both plans, a conservation plan and a conventional plan. So, somebody didn't get the word? Because the problem we had some time ago was everything was automatically going into the conservation sub-plan envelope. So we decided that there should be 2 plans presented for these applications, a conventional one and then a conservation plan. So, why are we running around here looking for something else when it's supposed to be required up front for an application? I mean, that's an administrative thing, sure, but
Yeah, well, I think the issue is that the same information has to be provided on both. That's what it comes down to.
Paul?
Go ahead, Mike.
So one of the items I saw in the letter there was on the zoning board's review was something about the grading of the land, the steepness of the land, and whether, lots, are buildable on that type of steep area. So that wasn't provided,
If it
And-
wasn't provided for the conventional, based on what I'm hearing, it does, I'm sorry, for the conservation plan, then it does not have to be provided for the conventional.
Okay, so
That's
it's,
what I'm hearing.
yes.
That's correct.
So even though the zoning board requested it, are they saying it was information that should have been provided?
The state law dealing with what are known as steep slopes
Yeah.
was changed so that municipalities can no longer take that type of land mass out of the buildable lot area. So I would advise that requiring that information does not comport with state law.
Okay.
In the master plan stage?
The zoning board said only that the applicant was missing wells, septic facilities, residences, and some wetland features. So
Okay.
I would advise that you stick with that language.
Okay, I just want to make sure that that wasn't required too.
Now I have a question.
Okay, Bill?
So if this motion is successful, and can we also maybe include, Paul, that, does the application need to be certified complete again by staff?
It was already certified complete.
The
And
application
now,
was.
just based on what the zoning board is saying, they are saying that you should
Okay,
consider
so-
this new information, so I don't believe that a new certification is required.
Okay, so how about simply, certainly going to be reviewed by town staff and conveyed to the board that the information requested is now contained with the application. Is that, it's fair to say?
Yes.
That's,
Mr. McGillivray, let's hear it. Please come to the mic.
Just for a point of clarification, so you don't have an error going forward here, above the language cited by Ms. DeSotel, it says, not only the need for septic and wells properly spaced apart, but how dramatic changes in grade will be handled is information that should be submitted as well. I think the issue of whether it's in developable area for the conservation plan is different from the land constraints depicted on the conventional plan, if that makes any sense. There's a formula for the conservation plan where you determine how much developable land you have. And yes, you shouldn't consider steep grades in that. But on the conventional plan, when you're looking at land constraints, things that would constrain development in a conventional setting without a conservation statute, you need to look at the grades. And the zoning board tells you have to do that. I just want that to be clear so you don't miss a piece of information and have everybody shouting at the next meeting that you don't have something you need.
Thank you. Everyone ready to vote?
Is that included? No?
I think it will be shown.
Yeah.
We have to evaluate it.
One other question. Has it been shown on the conservation plan? Was that piece
With
of
the
information provided?
the plan included topographical information, did it not?
Yes.
Yeah, so the slope is there.
Okay.
Everyone ready to vote? The motion is to request the applicant to submit information that is shown on the conservation plan, to submit parallel information for the conventional plan so that the same information is available for both plans. All those in favor say aye.
Aye.
Opposed, nay.
Nay.
Motion passes 5-1.
motion to adjourn?
Hold on. Is there any other business to bring before the board this evening?
Does the board wish to consider continuing the matter to a date? Or
Consider what, Ron?
continuing this matter to a specific date?
That's a fair question.
Yeah.
Let's look at our calendars.
If we don't do that tonight, then we have to re-advertise and renotice.
You suggest a suggestion, Ron?
If it goes on the agenda for our next regular meeting, it goes under old business, I suggest we select a date for a special meeting and not submit it for the next meeting.
You want to select a date tonight for a special meeting?
If we can, yes.
Okay.
You don't think it belongs on the regular meeting agenda?
I don't think we'll be able to.
Well, I mean, we don't have an awful lot on
we don't know what's going to be on the agenda. Everything comes in.
But
I,
I disagree.
I'm suggesting we set a date for a special meeting for this.
My schedule's tough. I blocked out planning board meetings, and that's challenging enough. So special meetings are gonna be a challenge unless it's something that I think is gonna take hours upon hours, and I don't necessarily think it is. Well, we can try a date, though,
It's
right?
also what else is on the agenda that could take hours and hours.
Sure, we can try a
So
date. I'm
that's
willing
why
to look at
I
my
am
calendar.
proposing we select a date for a special meeting.
Yeah, well, let's look at our calendars and see what we've got.
How much time do you need for notifications, Ron?
If I have to re-advertise, couple of weeks, I think 14 days is a requirement. If you select a date tonight and you announce it, we do not need to re-advertise. That's my point. If you don't select a date tonight, we do it later sometime, I have to re-advertise, re-notify.
When's that? So our next meeting is what, in 3 weeks?
September 8th.
3 weeks from tomorrow. Can we at least move it there? And then if we need to select a date beyond there, we can at least, by then, we can poll everybody, and so just,
Well, that's adding another.
it's better than-
We'll have to notify, we'll have to add the time to notify again.
No, if you continue it to your next regular meeting for control
For control.
purposes, then at that regular meeting, if you can set the date.
and then we can have a better handle on what our calendars are.
That would give them enough time for notifications. and
But we don't have to notify, that's the thing.
And advertising.
I'm trying to avoid having to.
Yeah, no, trying to
Let's,
avoid
the,
do you
expense.
need a motion for that, Ron?
We do need a motion.
You have a motion to continue this to the September 8th meeting.
So moved.
Second?
Any discussion? All those in favor say aye.
Aye.
Opposed, nay. The item is moved, it's continued to the September 8th meeting.
You got something?
Any other business to come before the board?
Steve McGilver again. So that will be just for control purposes. There won't be an actual hearing. You'll set a date at that point for a special session.
That's what it appears to be,
Well,
yes.
control, yeah.
Then the other question, and I'm sorry to take up your time, but I just want to have as much clarity as possible. I'm wondering if it's possible, one, to set a date when the additional information will be provided, so we'll have an opportunity to review it.
I think that's up to the applicant. Why don't you talk with the applicant? You can talk directly to him.
Okay, which we do. I've talked to him before this hearing as well. I'm not trying to put you in the middle on this
No,
one.
I'm not going to get in the middle, believe me.
Well, find a date that works for both of you, and
Yeah,
then
just-
we can talk about it on the 8th.
Okay,
Go
that
through
sounds good.
Ron, you know?
Well, one last question, again, I apologize for taking up your time, but just for point of clarification. The zoning board did say that cross-examination of the expert should be allowed. I don't know if that has been considered, and the exact language is, given the contested nature of this matter, cross-examination of witnesses should be permitted as it relates to the relevant areas of inquiry in order to approve or deny the master plan application.
That has happened for other applications, so I'm assuming it would happen for this one if it were desired.
It is, and I just wanted to make sure that's clear because Mr. Hool in particular gave testimony, but there wasn't an opportunity, according to the zoning board, for cross-examination, and the zoning board said that opportunity should be provided.
It will be provided. It's something that is typically done if it's requested.
Perfect. Thank you very much.
Yeah.
And again, I'm sorry to take your
Mr.
time. with the
Lynch.
questions.
Just one issue, and I hate to, I don't want to, I know your time is valuable. If we're on the agenda for the 8th, and if the board does have time, if your agenda falls apart and you have sufficient time to hear this, would ask that you still consider hearing it.
That will be the case. If there's no time available, or if it's a busy agenda, we will take the action to set a special meeting for it.
And maybe, let us know in advance so they can get their witnesses.
Well, it will depend on what else is on the agenda, as you know, Jay.
Yeah.
So,
So I recognize that my motion was not for control, so
And you'd also have to, excuse me, you'd also have to be very careful about how you put it on the agenda. If it's just for control and you're notifying the public of that, you cannot then go forward on
Okay,
the merits.
so that
Mr.
answers that.
Kurchuk, may I address that after Mr. Nash? I'm sorry, I didn't mean to.
So that was my motion, I believe, was not for control. I didn't, but that was my intent. But I mean, at this point,
So your intent was that it be on the agenda for consideration, and if we can, we will, and if we need something else or something else comes up, we'll set a special meeting. So,
Yeah, so
but it
it's-
will be there for consideration.
Just out of fairness to the objectors, who did bring all of their witnesses here tonight because we had no guidance as to what would happen, and we assumed weeks ago that the zoning board's dictates would be followed by the applicant. So we spent quite a bit of time preparing for this hearing tonight. We really would prefer, and I think it would be unfair to make us prepare again, not knowing whether we're going to go forward again on that night. We have 3 witnesses and a cross-examination.
We will do the best we can.
Okay.
I know the planning department is sensitive to this issue, so we'll do the best we can.
Then I would ask again that at least a week before that hearing, the additional information is submitted, so we don't all get this information.
That's a requirement of the planning board, by the way.
Okay.
We do not like to get information at the last minute.
So then the due date is a week beforehand.
We should have it at least a week beforehand.
Thank you.
Yeah, you're welcome. Anything else to come before the planning board?
Well, I want to go back again and remind everybody what master plan, the parameters are. Now, I hear all this witnesses. What are the witnesses going to be telling us?
Well, I just want to stop you there. You've already voted to continue this matter, so I think that
Yeah,
you're
let's wait and
close.
see.
Yeah.
Let's wait and see. May I have a motion to adjourn the meeting, please?
so moved.
Second.
Motion's made and seconded to adjourn. Any discussion? All those in favor say aye.
Aye.
Opposed, nay. Meeting's adjourned. Thank you all very much.